You've probably heard of the Takings Clause of the Fifth Amendment. But does the Constitution allow a county to take and sell someone's land to make a profit? That's the main question of the case Pung versus Isabella County, which we'll look at next on the Constitution Study.
Lovely neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach, Rise, and Generation be free. Glad you could join me today. The Takings Clause, it's one of those clauses of the Constitution that often gets misinterpreted, and I think it does here as well. But let me get into the episode, and we'll get into more details. If you want to find out more, if you want to follow along, we'll go to the website, constitutionstudy.com, find the article. I have links to all my sources so you can double-check my work. I'll talk more about the website and ways you can support the work that we're doing here at the end of the episode. But for now, let's take a look at this case, Pung versus Isabella County. I don't know anyone who likes paying taxes. It's just one of those things you have to do as an adult. But contrary to what some people say, not all taxation is theft. We delegate to government, both state and federal, the power to tax, but that taxation has limits. So when does taxation become theft? Now, this case was filed by Michael Pung, representing the estate of Timothy Scott Pung, and in it he claims Isabella County confiscated the Pung estate's private home for approximately $2,200 in taxes and fees that were never actually owed. How Isabella County handled the Pung estate is truly disturbing. In 1991, Timothy Scott Pung purchased his home located on St. Andrews Drive in Isabella County's Union Township for $125,000. In Michigan, a property owner may claim an exemption from certain local property taxes if the owner occupies the property as his or her principal residence. That's Michigan Law 211.7cc1. This exemption is called the Principal Residence Exemption, or PRE. Like nearly all Michigan property owners with a primary residence, Timothy filed for it and his property was granted the PRE credit, thereby reducing the annual property tax bill. Many states have laws that allow discounts or exemptions for landowners that meet certain conditions, so this law is not the problem. It appears that a single local official is the problem. 14 years later, Timothy unexpectedly passed away, leaving a wife and 2 children without their father. In the years that follow, Patricia DePriest, the Union Township tax assessor, retroactively denied the PRE credit for the Pung property for 2007 through 2011 tax years. After various challenges before the Michigan Tax Tribunal, the PRE credit was ordered to be fully restored. For reasons that are irrelevant to this petition, DePriest decided to and did once again revoke the property's PRE credit for the 2012 tax year. This led to a $2,241.93 unpaid tax bill for a tax that was never actually owed. I know of no law that would prohibit Ms. DePriest from canceling the PRE credit for future tax bills. However, retroactively depriving the credit is not only unjust, but a violation of Article 1, Section 10 of the Constitution, which reads, "No state shall, among other things, pass any bill of attainder, ex post facto law, or law impairing the obligations of contracts." While the tax court agreed with Mr. Pung, ordering the credit to be fully restored, it appears that Ms. DePriest ignored the order and revoked the credit for a different year. But this was not the end of Mr. Pung's nightmare. After more proceedings, the Michigan courts ultimately authorized the foreclosure over Pung's strenuous objections and challenges because DePriest failed to provide timely notice of the 2012 revocation, and Michigan's various tribunals found themselves powerless to fix the error. Based upon the quote-unquote unpaid yet not owed $2,241.93 in tax resulting from the removal of the PRE credit, Isabella County initiated proceedings and effectuated foreclosure. And despite Pung's serious efforts, the Michigan courts would not halt Isabella County Treasurer's demand for foreclosure on a tax never owed. So Mr. Pung's home was foreclosed on, stolen, to pay taxes his family did not owe. based on the dubious revocation of a tax credit for which a tax court had said was valid for previous years. The Union Township, through their tax assessor, failed to provide proper notice of the revocation and allegations of taxes owed, claimed the power to foreclose on property, and the Michigan courts claimed there was nothing they could do. So much for courts of law and justice. The questions Mr. Pung has brought to the Supreme Court are whether taking and selling a home to satisfy a debt to the government and keeping the surplus value as a windfall violates the takings clause of the Fifth Amendment when the compensation is based on an artificially depressed auction sale price rather than the property's fair market value, and whether the forfeiture of real property worth far more than needed to satisfy a tax debt but sold for a fraction of its real value constitutes an excessive fine under the Eighth Amendment, particularly when the debt was never actually owed. Now, oral arguments were held by the court on February 25th of 2026. As always, all arguments begin with the attorney for the petitioner.
Mr. Chief Justice, and may it please the court, the Fifth Amendment requires just compensation be measured by the value of what's taken. The Sixth Circuit's categorical rule reducing just compensation to surplus auction proceeds in all instances was wrong.
Mr. Ellison is resting his case on the Fifth Amendment's takings clause. Now, there is a flaw in that argument that I'll look at later.
This court has repeatedly confirmed that when the government takes property, the constitutional calculus begins with its fair market value. That is measured from the time of the take. The error here is clear. The Pung home was worth $194,400. The tax debt was roughly $2,200. Just compensation meant returning remaining equity. The lower courts erred when holding that the later auction price of just $76,000 less the debt was categorically the only just compensation owed.
The real question is what compensation is just. Merriam-Webster Online Dictionary defines just as conforming to a standard of correctness. So if you own a home worth almost $200,000, does the $76,000 it was auctioned off for really conform to the standard of correctness? According to Mr. Ellison, the court had previously said no. There's another argument to be made. Mr. Ellison claims that not only violations of the taking clause, but the Eighth Amendment's excessive fines clause as well.
In addition to the Fifth Amendment, the Eighth Amendment's excessive fines clause provides a backstop as well. Taking a six-figure home to punish over a small four-figure tax constitutes a fine and was sufficiently alleged to be grossly disproportionate to get past the initial pleading stage. The judgment below should be reversed, and I welcome the court's question.
That's the position of Mr. Ellison for Mr. Pung. What about the other side? Mr. Nelson represents Isabella County and the Union Township.
The Sixth Circuit here correctly applied historic practice, this court's precedent, and economic reality to determine that surplus proceeds, from an auction sale, less the tax debt that's owed, establishes just compensation. Property sold under in a compelled market, under compelled market conditions, is worth what the market pays for it under those conditions, and not what the property would be worth in an idealized private sale.
The problem with Mr. Nelson's argument is that the government created the compelled market in this case without legal foundation. Remember, Ms. DePriest was ordered by a court to restore Mr. Tung's tax exemption. She apparently complied, only to subsequently revoke exemption for a different year.
By contrast, Petitioner's fair market value theory has no foothold in historic practice, this court's precedents, or economic reality. Even though the government has been selling properties at auction and returning the overplus for centuries, not a single case has ever suggested that the surplus proceeds are equal to the property's fair market value less the debt.
I'm not sure about court precedent, but Mr. Ellison's argument is based on the supreme law of the land, the Constitution of the United States. Shouldn't that be enough?
Moreover, the petitioner's fair market value approach assumes market conditions that simply don't exist after a foreclosure because the property owner's decisions not to pay the tax, not to sell the property, not to obtain a statutory deferral, and not to exercise the right of redemption. The takings clause does not require compensation to the owner for owner-created reductions to the property value. That would be unjust to the government and to the public. I welcome the court's question.
Again, it seems Mr. Nelson has forgotten that Ms. DePriest had a court order to restore the exemption, only to change the year and focused allegedly without sufficient notice. That means that Mr. Pung did not owe the Union Township any back taxes. The alleged depression of the property's value is solely the consequence of the questionable actions of Ms. DePriest. Mr. Ellison is basing his argument primarily on the Fifth Amendment's takings clause, but there's a problem with that. What the township took the property for. Nor shall private property be taken for public use without just compensation. But the court keeps going to history and tradition. This property was not taken for public use, but to pay an alleged public debt. This action did violate the Fifth Amendment, just not the takings clause. I'll discuss that in the section on due process.
What do you do with the fact that the English and American legal traditions seem to permit these sorts of foreclosures?
Legal tradition may allow such foreclosures, but that is not the supreme law of the land. The Constitution is. Justice Sotomayor asked a similar question.
Suggested, give me a holding from a court in our 250-year history where we have said that the measure of damages on a tax foreclosure is fair market value, not the auction price.
Rather than tradition, Mr. Ellison points to the law.
The answer is that the Fifth Amendment guarantees just compensation. It doesn't guarantee the outcome of an auction.
Which begs the question, what is just compensation? As I've already pointed out, Merriam-Webster's online dictionary defines just as conforming to a standard of correctness. What does that mean in the real world?
I think your fallback position or your main position is just compensation under the Constitution requires fair market value.
Correct.
If I disagree with that, and I believe just compensation should be defined the way Justice Scalia did in BDP, which is what's reasonable under the circumstances. And I believe that a valid auction is a reasonable compensation. You lose on your main argument, correct?
We would if you do not believe that fair market value is the standard, correct.
Mr. Liu argued for the United States as amici. While claiming not to support either side, his argument on this point clearly appears to support Isabella County's position.
According to Petitioner, compensation should instead reflect a property's fair market value. But as this court recognized in BFP, foreclosed property is simply worth less.
Which is the point. Governments have used the power to foreclose to artificially depress the perceived value of property in order to exercise eminent domain at a discount. What about foreclosure makes a $200,000 property worth only $76,000? Nothing. The person who bought the property at auction simply made a $76,000 investment to acquire a $194,000 property, a nice $118,000 unrealized profit.
Except for someone did, shortly after the auction, buy the property for the prior $194,000. Doesn't that give rise to some reason to be concerned about the procedures that your client used?
No, Your Honor. The procedures here have been the historic process that have been used since the beginning of the Republic.
Not a bad payday for whoever bought that property. It also proves the point that simply because a property has been foreclosed on, its market value does not automatically decline. So why is Isabella County fighting this so hard?
Petitioner's approach would defy that reality and spell the end of tax sales in this country.
Because governments want to be able to take people's homes? Or is it they don't really care about the equity people lose? Or as long as the government gets its tax dollars? Justice Thomas looked at this from a different point of view.
What was the assessed value on which the tax was imposed?
The assessed value here was approximately $194,000.
Can Petitioner use that as a basis for its disagreement with the foreclosed sale value?
Interesting question. You see, Union Township valued the property at $194,000 before the foreclosure, not after it. Of course, the original valuation by the township was for the purposes of imposing taxes, so they would benefit from a higher valuation. Could this be a basis for Mr. Pung's disagreement?
Justice Thomas, we do not believe so because if the measure of the property's value is at the time of the taking, it's either if the taking is the surplus proceeds, then the amount of the surplus proceeds is what's taken. If the property value is the equitable interest in the property at the time that the right of redemption expired, the property was no longer worth the assessed value under market conditions because the property was in foreclosure and the right of redemption had not been exercised, such that the value of the equitable interest in the property had diminished to a forced sale value, which we believe is the teaching from BFP.
So the value decreased approximately $120,000 in that short period.
Remember, the alleged decrease in the value of the property had nothing to do with the property itself. It was wholly created by Ms. DePriest and the township for its own benefit, the collection of taxes that a court had found to be unlawful.
We believe that the property decreased in value by a very significant amount between the time of the assessment and the time of the foreclosure, the expiration of the right of redemption because of the non-payment of the tax. No reasonable buyer out in the market would acquire the property at the moment of the taking here for the $194,000.
Except, as Justice Gorsuch has already pointed out, someone did acquire the property for the full $194,000 valuation shortly after the auction. Mr. Ellison argues that the difference between the auction price and the assessed price constitutes an excessive fine. I think he has a point. After all, should the failure to pay an alleged $2,200 tax come with an $118,000 fine? I don't think so. I think a better argument is a violation of the 5th and 14th Amendments' due process clauses, which both read, "No person shall be deprived of life, liberty, or property without due process of law." Justice Jackson raised the point when questioning Mr. Ellison.
Can I just follow up on that? Because I'm wondering whether or not that kind of concern doesn't ring more in like a due process claim rather than just compensation. Because to the extent you're arguing about, or your claim is that they needed to do other steps before they took the property, I didn't understand the takings clause to be concerned about pre-takings deprivation, that the takings clause was just about just compensation. And so wouldn't you be needing to bring a kind of a due process type claim if you're complaining about the personal property aspect of this?
We would acknowledge that due process comes awful close in the just compensation world, but the question that's being challenged here is, does the result of this foreclosure process result in just compensation?
Yes.
There's still that problem that Union Township did not take Mr. Pung's property for public use, but to pay a public debt. Can a government take a person's property for failure to pay a public debt? Yes, but they have to follow due process, which is defined as an established course for judicial proceedings or other governmental activities designed to safeguard the legal rights of the individual. Did the Union Township safeguard the legal rights of Mr. Pung when they foreclosed and auctioned off his property for the tax they allegedly owed? Justice Alito asked about the question of the consequences of not paying taxes. But as Mr. Ellison pointed out in response, Mr. Pung did not owe taxes because Ms. DePriest retroactively denied a tax credit for 1 year after the credit she was forced to reinstate. And she allegedly entered foreclosure proceedings without sufficient notice of the ex post facto denial of the credit. So whether or not Mr. Pung actually owed any taxes should be questioned. Mr. Nelson, defending the foreclosure, stated,
after the property is turned over now to the county, who is the respondent here, when it's turned over to the county has no authority to say, now this tax should not have been paid, unless what happens is...
Oh, goodness. Really?
Unless...
nobody can say, hey, there was a mistake.
Well,
I have to foreclose on someone's home for a tax bill I now know is false, but I'm forced to do it.
Oops. The county has to foreclose on a property for a tax bill they know is false? That doesn't sound right. Mr. Nelson argues that Mr. Pung had the opportunity to challenge the tax bill in court.
Your Honor, the petitioner here had the opportunity to come to the show cause hearing or the foreclosure hearing, the show cause hearing with the treasurer, or the foreclosure hearing with the court and say, this tax was never properly assessed. At that time, there is an opportunity to say the tax is not properly assessed. We're going to go ahead and reverse this whole process, and we're in the clear. But that didn't happen.
I wonder why Mr. Pung or his attorney didn't attend either hearing. I couldn't find anywhere in either of these oral arguments or the petition for certiorari where these hearings were mentioned. I wonder, since there was a hearing on the revocation of the tax credit for the previous years, was there a communications breakdown? Was Mr. Pung given proper notice?
Well, I think what the facts of this case show is that Mr. Pung was given notice of the delinquency. I mean, he face-to-face was told by the township assessor that he owed the tax.
And he went to tax court, and the tax court said, no, you don't. And he presented the government with that notice, and the government said, bye.
Right. And I think this is an unusual feature of this case, that while Mr. Pung did appeal the denial of the principal residence exemption as to certain years, he didn't appeal that denial as to the year at issue here.
Could it be because Ms. DePriest didn't deny the exemption until after the tax court told her no on previous years? What changed between 2011 and 2012 that a court would find sufficient to allow the denial to stand? Nothing I saw. This was not a violation of Fifth Amendment's takings clause. It was not a violation of eminent domain like we've seen so often in the last couple of decades. It was far, far worse. This violation of the due process clauses of the Fifth and 14th Amendments amounts to flat-out theft, and the actions of Ms. DePriest seem more like a vengeful grudge than the due process actions of a government actor, something that was not lost on Justice Barrett.
So, counsel, I want to echo what Justice Gorsuch said. I mean, it seems like there was some real unfairness to your client. I mean, frankly, reading the briefs, it sounds to me like this tax assessor was like Inspector Javert, but it was even worse because Jean Valjean hadn't stolen the bread. I mean, you didn't even owe the tax, and it's this small tax and the big, the big loss of the family home and of the money. So it does seem that there's some unfairness there.
Now, court watchers seem to think the court leaned toward Mr. Ellison's argument for Mr. Pung. We'll have to wait and see if their prognostications are correct. Yet taxes may be a necessary evil, but that's not what I see here. What I see here seems to be more like theft and revenge than the application of taxes, which makes it that much worse. The fact that the court seems to be leaning towards Mr. Pung may be some relief, but what about Ms. DePriest? Were her actions legal? Were they criminal? What about the actions of the courts? Who's looking at this saying, wait a second, how did this exemption suddenly happen, and was proper notice given? Because it does seem like Ms. DePriest has some sort of vendetta against Mr. Pung. I don't know if it's personal or just a dislike of these tax credits. I don't know. I don't know the lady, and I have no basis to make such a decision. What I see here are clear violations of the due process and quite possibly an excessive fine. We'll have to wait and see what the court comes up with their decision. Either case, imagine yourself in Mr. Pung's position. Your family home is taken because of a tax that you don't really owe, then sold for pennies on the dollar, only to have you not receive the proceeds of the sale beyond what you allegedly owed in taxes. It's not like this is something that can be fixed overnight, right? Mr. Pung isn't suddenly going to get his property back. It's already been sold. It's been auctioned to somebody else. There is no redress of that grievance, not really. I can only hope that not only will the township, Union Township, be forced to reimburse Mr. Pung the entire value of the property, not the $76,000 it was sold for, the $194,000 they valued it at, and that Ms. DePriest get referred for investigation into her activities and how she went about doing this. We can wait and see. We can hope. But that's why it's so important to know what your rights are and be able to defend them. It's why we created the Constitution Study. Go to constitutionstudy.com and you'll find all the work that we do there. These articles, these videos, these radio episodes, my other radio program, all sorts of content. Of course, you can look at this article and look at my sources because I want people to check my sources. I want people to know what I'm getting from other places. If you'd like to support the work that we're doing, of course, go there and share that content. But you can also go to the store, constitutionstudy.com/shop, and purchase a book or a t-shirt or a mug, or just donate to the cause. It's all available there. You can also support us with your cell phone. Go to patriotmobile.com/constitution, sign up for a plan. Patriot Mobile is America's only Christian conservative wireless provider. They support organizations like the Constitution Study that are protecting your rights. Oh, by the way, if you use the code Constitution at checkout, you get your activation absolutely free. So you can support the work that we're doing with your cell phone and get great cell phone service as well, just by going to patriotmobile.com/constitution, and don't forget, use that code Constitution at checkout. I also hope that you enjoyed this episode and all the episodes that we do here. And I hope you'll come back and bring a friend or two the next time we meet for the Constitution Study.
Love the neighbors and have a few good friends.